Hello again. A revocable living trust is the most common and effective way to avoid probate, but it's not a guarantee. In fact, a number of people still end up in probate despite having a trust. How does that happen? In this video, I'm going to go through 9 reasons that allows a person with a trust to still end up in probate. Stay till the end. I will provide a quick checklist on how to increase your chances of avoiding probate. Okay, reason number 1 is not getting the trust signed properly. By properly, I mean according to your state requirements. A trust needs to be signed, notarized, and a few states may need it to be witnessed. Sometimes the entire signature page is missing. Sometimes it's signed but not notarized. Sometimes the wrong version of the trust was signed. Whatever the reason, an invalid trust equals no trust equals probate. Reason number 2 is not getting the trust funded. That's a technical term for transferring assets out of your title, out of your name, into the trust. Friends, this is the bottom line, okay? If I die and any of my assets are still in my name, then the probate courts have to step in to supervise the transfer of the assets from me to my heirs because I'm no longer alive to sign off on the title. So that's what this step is, to make sure that all your assets have been transferred from my name into the trust. Reason number 3 is haphazardly transferring assets into the trust without first creating a list of assets, also called a schedule of assets. This list helps you track more methodically what are all the assets you have, the different types, and to make sure that none of them has been forgotten. Because like I said, you only need to miss one asset to end up in probate. A word of caution here, a list, keeping a detailed list, is not the same as funding the trust. Some people mistakenly believe that if they have a very detailed list, they print it out, they sign it, they attach it to the trust, that's equal to funding the trust. It's not. You have to actually take the action of retitling the assets into the trust. A list is simply a document that tells you what your assets are. Reason number 4, sometimes simple typos could cause you to end up in probate. So make sure you check the spellings of all the names in your trust. And also when you transfer titles of your assets from your name into the trust, make sure to have the certification of trust next to you so you can refer to the trust name exactly precisely as it is stated in the certification of trust. Here's an easy way to remember. Our names have 3 parts, right? First name, middle name, last name. Well, most of us. Same thing for a trust. You need 3 components: the name of the trust, the name of the trustee, and the date of the trust. So check all your spellings. Don't let typos be the reason to cause you to end up in probate. Reason number 5 is not making sure that your title transfers went through correctly. For example, if you transferred your house from your name into the trust, did it execute properly? A couple of tips for you here. Okay, 1, if you are doing it yourself, always show up in person at your local county records registry of deeds and ask them in person what are the requirements for the transfers. And when you have fulfilled those requirements, go in person to submit the new deed. So if there's anything that's missing, they could let you know firsthand instead of you just sending it off by mail and assuming that everything went through. So that's the first tip. The second tip is that even if you think you did it 100% correctly, you want to verify. If you did a house deed transfer, for example, look up the county records registry of deeds online and make sure that you now see the trust name on the deed, not your name anymore. If you transferred your investment brokerage account into the trust, then when you get the account statement the next month, check to see that the name on the statement is the trust name, not your name anymore. The next 2 reasons shows the importance of reviewing your trust regularly, especially the key roles. If your successor trustee or executor are not able to serve and you don't have a backup, then the probate courts would have to step in to appoint appoint someone else to cover those roles. And it's easy to happen. Perhaps your successor trustee has relocated to Europe and is no longer willing to serve, or perhaps your executor no longer has the mental capacity to serve as executor. If you don't have a backup, then your estate will end up in probate. Reason number 7, purchasing new assets, new property, and not remembering about the trust. If you have a revocable living trust, you can purchase property or assets with the name of the trust. That will save you a step because you're not buying it in your name and then transferring title from your name into the trust. Because, when you buy something new, you're excited, right? Maybe you're refurbishing it, maybe you're improving it and enjoying it and making it better, having so much fun that you might forget to transfer the asset from your name into the trust. So if you can, buy the property directly using the name of the trust. Reason number 8, you could still end up in probate despite having a trust. It's poor drafting, unclear language, conflicting clauses. Your kids could end up arguing what mom and dad really meant. Family fights, disputes, disagreements, first in the living room and then in the courts. That's probate. What's worse, if the kids end up not talking with each other because of the conflicts and the tension, that's even worse than probate. Reason number 9, an over-reliance on the pour-over will. A pour-over will is something that goes together with a revocable living trust to provide a safety net in case there are assets you forgot to title into the trust. It will tell the judge, hey, sorry about that, the intention is to pour the asset over into the trust. So it helps making the process smoother, but you will still have to go through probate. Now, there are situations when it's not avoidable. For example, a client of mine, his dad passed away in a car accident and the judge awarded him the settlement from the other party. So that pile of money wasn't in his dad's trust, right? Fortunately, because his dad had a pour-over will, the money went smoothly into the trust, but they still had to go through probate. All right, we've come to the last one. Reason number 10. It's not so much a problem with the trust. It's a problem with the assets that are not included in the trust. I have a video listing 10 assets that should not be part of a trust. For example, an IRA, which stands for Individual Retirement Accounts. It needs to belong to an individual, not a trust. If you make the mistake of transferring the IRA from your name into the trust, the IRS considers that a withdrawal and a tax is immediately due. So there are certain assets that don't belong in a trust, like retirement funds, 401k, life insurance, annuities, HSAs, health savings accounts. But it doesn't mean that you should just ignore those assets. You need to make sure that those assets have a named beneficiary, whether to a specific individual or to a charity or to a trust. If those assets don't have any named beneficiaries, they will cause you to end up in probate even if you have an ironclad revocable living trust. So those are the 10 most common reasons to watch out for. Now here's a quick list of things you should do. 1, make sure you sign, witness, and notarize your documents, not just the trust, but also the pour-over will, the certification of trust, all the documents in your estate plan. Make sure you meet the requirements of your estate. 2, make sure you fully fund your trust. And the best chance of you doing that is by starting with a list of assets first, so you don't miss or forget any asset. 3rd, have backups. Backups to your successor trustee, backups to your executors, because it's actually not uncommon for folks that have said yes to you to perform those roles and then changing their minds later. Sometimes they can't help it, maybe they have a health reason, but having backups is the sure way that you're covered and don't end up in probate. Even if you do have backups, 4, you still want to review your trust document, your pour-over will frequently because families change, family dynamics change, your asset profile changes, tax laws change. So review your trust at least once a year. 5, have clear language and check for inconsistencies among your estate plan instruments so that your family doesn't end up disputing about your intentions and ending up in the probate court. And finally, the assets that you should not transfer into your trust, don't ignore those assets. They still need a named beneficiary, not just one. You need a primary beneficiary, and I usually put 2 contingent beneficiaries. I reference a video about 10 things you should not put into your trust. If you haven't seen the video, I'll put the link in the description below and also at the end of this video.